am attorney Marie-Chris Bathan-Lasco. This is my virtual classroom. Welcome to my YouTube channel. In this channel, I shall aim to simplify the law. I will discuss concepts and principles of law in under 10 minutes. Hello everyone, welcome to MBL Classroom. For this video, I want us to talk about bylaws. What are bylaws? How do we adopt bylaws? Can we still change the bylaws of a corporation? And how do we go about such change or amendment in the bylaws? So what are bylaws? The bylaws are actually the rules and regulations of a corporation. These rules that will direct the affairs of the corporation, these rules that will govern the stockholders of a corporation, and also those officers or those who are managing the affairs of the corporation. Do not confuse the bylaws with your articles of incorporation. Your articles of incorporation actually serves as the fundamental law of the corporation, while the bylaws, as we mentioned, are the rules and regulations adopted by the corporation. Also, the articles of incorporation is made before the incorporation of the corporation, as in fact, that is a condition precedent of creating a corporation. That is what you submit to the Securities and Exchange Commission so that you may be granted a personality as a corporation. While your bylaws usually are made or created after incorporation, and we also call it a condition subsequent of your incorporation. Can we view bylaws also as a contract? The answer is yes. It is actually also viewed as a contract between the corporation and the stockholders. What then do we see in the bylaws? We see in the bylaws details that are not important enough to be placed in the articles of incorporation, but important enough to be put in writing as a guiding tool in directing the affairs of the corporation. The function of the bylaws is to define the rights and duties of the directors or trustees or the officers and even the stockholders of the corporation towards the corporation in relation to governing the affairs of the corporation. So when does a corporation adopt its bylaws? You actually see that under Section 45 of your revised corporation code. Section 45 tells you that the adoption of the bylaws may be done after incorporation, or it may even also be done prior to incorporation. Let us read the first part of Section 45. It says, for the adoption of bylaws by the corporation, the affirmative vote of the stockholders representing at least a majority of the outstanding capital stock or of at least a majority of the members in case of non-stock corporations shall be necessary. The bylaws shall be signed by the stockholders or members voting for them and shall be kept in the principal office of the corporation, subject to the inspection of the stockholders or members during office hours. A copy thereof, duly certified by a majority of the directors or trustees and countersigned by the secretary of the corporation, shall be filed with the commission and attached to the original articles of incorporation. Notwithstanding the provisions of the preceding paragraph, bylaws may be adopted and filed prior to incorporation. In such case, such bylaws shall be approved and signed by all the incorporators and submitted to the commission together with the articles of incorporation. The first paragraph of Section 45 tells you that after the incorporation of a corporation, there is now the adoption of the bylaws. And your Section 45 also tells you that it will be your stockholders who will be voting on the approval of the bylaws. And what is the required vote according to Section 45? It should be at least a majority of the outstanding capital stock if a stock corporation, and at least a majority of the members if a non-stock corporation. Now, after a majority of the outstanding capital stock or majority of the members have approved the bylaws, what must be done next? Your Section 45 tells you that the bylaws must be signed by all the stockholders or members who have approved of the same, and that the bylaws must be kept in the principal place of business so that stockholders or members may be able to inspect them during office hours. What must be done also apart from that? There must be a submission of the bylaws with your Securities and Exchange Commission. And the copy that will be submitted to the Securities and Exchange Commission must be duly certified by a majority of the directors or the trustees and countersigned by the corporate secretary. As I've mentioned earlier, your bylaws may also be adopted even prior to incorporation. And how is that done? This is done by submitting the bylaws together with the articles of incorporation. And the bylaws must be signed by all the incorporators of the corporation. Now, when will the bylaws be considered as effective? Your Section 45 tells you that it will become effective only when it is approved by the Securities and Exchange Commission. Let's read the third and fourth paragraphs of Section 45. It says, in all cases, bylaws shall be effective only upon the issuance by the Commission of a certification that the bylaws are in accordance with this code. The Commission shall not accept for filing the bylaws or any amendment thereto of any bank, banking institution, building and loan association, trust company, insurance company, public utility, educational institution, or other special corporations governed by special laws, unless accompanied by a certificate of the appropriate government agency to the effect that such bylaws or amendments are in accordance with law. So what does that tell you? Even if it has already been approved by at least majority of the outstanding capital stock or at least majority of the members if a non-stock corporation, the bylaws do not become effective unless there is a certification by the Securities and Exchange Commission that your bylaws is in accordance with law. Moreover, Section 45, the last paragraph, also gives you an enumeration of certain corporations. Clearly, these corporations are vested with public interest, where before the Securities and Exchange Commission will approve such bylaws, you have to submit also a certification from the appropriate government agency where such certification will state that the bylaws are in accordance with certain special laws. These corporations, I have placed the list here. Now, what should you put in the bylaws? As I've mentioned earlier, these are the details that would supplement your articles of incorporation. Your Section 46 of the Revised Corporation Code gives you an enumeration of what you may put in the bylaws. Let's take a look at Section 46. It says, a private corporation may provide the following in its bylaws. A. The time, place, and manner of calling and conducting regular or special meetings of the directors or trustees. B. The time and manner of calling and conducting regular or special meetings and mode of notifying the stockholders or members thereof. C. The required quorum in meetings of stockholders or members and the manner of voting therein. D. The modes by which a stockholder, member, director, or trustee may attend meetings and cast their votes. E. The form of proxies of stockholders and members and the manner of voting them. F. The directors or trustees' qualifications, duties, and responsibilities, the guidelines for setting the compensation of directors or trustees and officers, and the maximum number of other board representations that an independent director or trustee may have, which shall in no case be more than the number prescribed by the Commission. G. The time for holding the annual election of directors or trustees and the mode or manner of giving notice thereof. H. The manner of election or appointment and the term of office of all officers other than directors or trustees. I. The penalties for violation of the bylaws. J. In the case of stock corporations, the manner of issuing stock certificates. And K. Such other matters as may be necessary for the proper or convenient transaction of its corporate affairs for the promotion of good governance and anti-graft and corruption measures. An arbitration agreement may be provided in the bylaws pursuant to Section 181 of this code. Now remember that the list under Section 46 is merely directory. In other words, if you miss something in the list in your bylaws, that does not make your bylaws invalid or ineffective. Again, the list there is merely a guide for corporations on what to put in the bylaws of the corporation. Because again, the bylaws are just merely rules and regulations that would guide the corporation in managing the affairs of the corporation, in determining the duties and responsibilities of the directors, the officers, the stockholders towards the corporation. Now, once the bylaws are approved and there is now a certification issued by the Securities and Exchange Commission that your bylaws is in accordance with law, can you still amend your bylaws? Or can the corporation decide to adopt new bylaws and repeal the previous one that was already approved by the Securities and Exchange Commission? The answer is yes. And you can find the answer to that under Section 47 of the Revised Corporation Code. Let's take a look at Section 47. It says, a majority of the board of directors or trustees and the owners of at least a majority of the outstanding capital stock or at least a majority of the members of a non-stock corporation at a regular or special meeting duly called for the purpose may amend or repeal the bylaws or adopt new bylaws. The owners of 2/3 of the outstanding capital stock or 2/3 of the members in a non-stock corporation may delegate to the board of directors or trustees the power to amend or repeal the bylaws or adopt new bylaws, provided that any power delegated to the board of directors or trustees to amend or repeal the bylaws or adopt new bylaws shall be considered as revoked whenever stockholders owning or representing a majority of the outstanding capital stock or majority of the members shall so vote at a regular or special meeting. Whenever the bylaws are amended or new bylaws are adopted, the corporation shall file with the Commission such amended or new bylaws, and, if applicable, the stockholders or members' resolution authorizing the delegation of the power to amend and or adopt new bylaws, duly certified under oath by the corporate secretary and a majority of the directors or trustees. The amended or new bylaws shall only be effective upon the issuance by the Commission of a certification that the same is in accordance with this code and other relevant laws. Section 47 will tell you that just like the adoption of the original or the first bylaws of the corporation, you would also be needing majority or approval or vote by a majority of the outstanding capital stock if a stock corporation, or at least a majority of the members if a non-stock corporation, if you want to amend your bylaws or repeal the existing bylaws or to adopt new bylaws. So again, the vote required is majority, at least a majority rather, of the outstanding capital stock or at least a majority of the members. Now, another thing under Section 47 is that your Section 47 allows that the power to amend or to repeal or to adopt new bylaws may be delegated to the board of directors. In other words, the stockholders or the members can actually delegate such power to amend, to repeal, or to adopt new bylaws. How is this done? you will be needing the approval of at least 2/3 of the outstanding capital stock or at least 2/3 of the members to delegate such power to the board of directors. In other words, if it were the stockholders or the members who will amend, adopt, or repeal an existing or the existing bylaws of the corporation, a lower vote is required. And that is the majority of the outstanding capital stock or at least a majority of the members. But if the stockholders or the members would choose to delegate this to the board of directors or trustees, then a higher number of votes would be required because the law now requires at least 2/3 of the outstanding capital stock or at least 2/3 of the members should they decide to delegate it to the board of directors or trustees the power to amend the bylaws or to repeal the bylaws or to adopt new bylaws. Now, can they revoke the power that they have delegated? The answer is yes. How? They will have to vote on it again. But what is the required vote? The required vote is only at least a majority of the outstanding capital stock or at least a majority of the members. Now, what does that tell you? It tells you that it is harder to delegate that power because a higher number of votes would be required. It's at least 2/3 of the outstanding capital stock or at least 2/3 of the members. While revocation it is actually easier because it only requires at least a majority of the outstanding capital stock or at least a majority of the members. And again, majority is 1/2 plus 1. Now, if the required number of votes have already been obtained for the approval of the bylaws, will the bylaws become effective then? Not yet, because again, you have to file the bylaws before the Securities and Exchange Commission, and it becomes effective again only when the Securities and Exchange Commission will issue a certification and approves the bylaws and certifies that the bylaws is in accordance with law. So that is all for your bylaws of the corporation. I hope you have learned something from this video and I will see you in the next. So if you find this video helpful, please click like, subscribe, and that notification bell so that you will be notified of new video uploads. Thank you for watching. See you next time in MBL Classroom.